Am I blocking you from working? Am I blocking? Shut up.
If I tell me to shut up right now, I can take you to jail right there for that. I'm trying to deal with him, and you come over here and tell me to shut up, my own call? Absolutely not. I can take you to jail just for that.
You can't just take my recording equipment. Evidence recorded everything. It's live stream.
Is it legal to tell cops to shut up? And equally important, if you get a super aggressive cop who grabs a hold of you and doesn't like it, can you sue them if they choose to arrest you? So what's going on in this video? James Freeman showed up and was recording a McKinney police officer in the middle of a traffic stop. As some McKinney, Texas police officers tend to do, they got upset at Mr. Freeman and started to give him a little bit of lip.
Sir, you can hear me in the black shirt. If you want to go to jail for being an officer, you stand back over there.
What?
More than welcome to film.
What?
More than welcome to film, but you have to give me space to work.
In response, Mr. Freeman looked right back at them and told them to shut up.
Am I blocking? Shut up.
Want to guess what happened here? They arrested him, supposedly for interfering with public duties. But wait, how is this possible? Isn't this free speech? I'm Jeff Hampton, the People's Lawyer, and in this video, I'm going to break down Mr. Freeman's encounter with these Texas police officers, and I'm going to break down number 1, can you legally tell a cop to shut up? Number 2, can you be arrested for it? And would this arrest be lawful? Number 3, what are the chances of actually being convicted for something like this if you tell the cops to shut up? And number 4, if you are arrested for telling cops to shut up, can you overcome qualified immunity and sue the police for taking this action? Number 1, can you legally tell a cop to shut up? Even though this McKinney police officer was unaware, the United States Supreme Court has answered this question in multiple cases. In the landmark City of Houston versus Hill decision, the United States Supreme Court struck down a city ordinance that made it unlawful to verbally interrupt a police officer during an interaction. Justice Brennan, writing for the court, said, and I quote, "The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers." He went on to say, and I quote, "The freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state." In other words, we are supposed to be living in a free society, which means it is not unlawful. You are allowed to disagree or even criticize and yes, even insult a government official, including a police officer, by saying something like shut up to them, as long as the words you use do not pose a clear and present danger to incite some type of violence. But this doesn't just apply to saying shut up. It actually goes to even verbal and physical actions you might do that could be insulting to cops. For example, the Ninth Circuit in Duran versus the City of Douglas, they ruled that in that situation, a man actually flipped off a police officer and shouted profanities at him. They said that was protected speech and it did not reach the level of posing a clear and present danger. The court then acknowledged that that particular gentleman's behavior was, quote, inarticulate and crude, but stated that it squarely was within the protective umbrella of the First Amendment and that police cannot use their authority to punish someone for speech that is merely offensive or annoying. The Duran court went even further when they bluntly said, and I quote, that officers may resent having obscene words and gestures directed at them, but they may not exercise the awesome power at their disposal to punish individuals for conduct that is not merely lawful, but protected by the First Amendment. In other words, cops might not like what you said. They might even be offended by what you said, but as long as it's not inciting violence, they can't use it as a pretext to now stop you or search you or attempt to arrest you just because they don't like you. Now, this is critically important, and many police officers forget this, but it is not a crime in and of itself to insult a police officer or say something to them that might be offensive. I'm not saying that we should do that and that someone should walk around telling officers those things, but there is no such thing as the crime of contempt of cop, even though many times people don't remember this. So yes, you generally have a legal right to tell a police officer to shut up. Now, as crude, or maybe some people will think in that situation disrespectful as it may be, it is still considered protected speech under the First Amendment, and an officer is not permitted to retaliate against you for doing so. But there are a few narrow circumstances where in this situation you could lose your First Amendment speech protection. For example, what is known as fighting words or true threats are not protected under the First Amendment. What is considered fighting words? Well, some courts have defined this as, quote, face-to-face insults likely to provoke an immediate violent reaction. However, courts have noted that this fighting words exception is especially narrow when these words are directed at police. In fact, courts have been very specific about this because they've said that police officers are expected to show a much higher order of restraint in how they respond to people than an ordinary citizen because of their training and experience. For example, in Lewis versus City of New Orleans, the Supreme Court overturned a conviction where a woman had cursed at a police officer. Justice Powell, in writing this opinion, was very specific. He said that the words from the woman might have been considered fighting words if she were talking to any other normal passerby. But when she used those words specifically to a police officer, it was expected that that officer would have had more temperance, being able to control himself, and showed a higher degree of restraint. As a result of that, the conviction was overturned. In fact, the court articulated that yelling "shut up" or using profanity at a police officer without something much more specific, would not rise to the level of inciting some type of violence or reaching those fighting words. It might be rude, but according to the court, it's absolutely legal. So now that we know the First Amendment broadly provides you protection to criticize, to curse, maybe even to be rude to a police officer, this leads us to question number 2. Can a police officer legally arrest you for this, all because he doesn't like the way you treated him? Legally, no. This absolutely should not have happened. Practically, unfortunately, it happens all the time. In fact, as James Freeman's case just showed us right now, an officer who either doesn't know the law or just gets upset, gets angry, and full of power, he might look at it and not care whether it's legal or not, still place you in handcuffs, still arrest you, and take you to jail. So it's not whether the officers can arrest you. The real question is whether it's lawful. This particular arrest took place in McKinney, Texas, so we're going to have to take a look at the Texas Penal Code and how they define interfering with public duties. Now, even though Mr. Freeman's situation falls under Texas Penal Code Section 3815 for interference with public duties, many states, in fact, most states, have a similar law that covers whether it's retaliation, interfering with an officer, obstructing an officer's duties. Most states have a similar statute. Now, the thing I can't stand about these particular laws is that in most states, including in Texas, the way they're written seems extremely broad. Like you could be arrested for doing almost anything that would equal interfering with public duties. However, when you look into the case law, what you'll find, the courts are a lot more specific about what this is. They say that you have to do something physically to hinder the duties of the officer, or as I was looking at it, you must actually disobey some lawful commands in such a way that would impede their duties. Mere speech does not rise to that level. So under Texas law, under statute section 3815, the law is written in such a way, I'm going to read this to you, that it says, quote, "It is a misdemeanor for a person with criminal negligence to interrupt, disrupt, impede, or otherwise interfere with a peace officer performing their duty." Now, at first glance, that looks extremely broad, but then if you read it, it continues to actually provide you a defense, a specific defense if what you did was speech only. In fact, it says, and I quote, "It is a defense to prosecution under this section that the interruption, disruption, impediment, or interference alleged consisted of speech only." In other words, if all you did is talk, you can't be convicted. Other states may not be quite as clear about the definition of interference with public duties or the actual defenses, but they still follow the First Amendment principles we're talking about here. For example, the Washington State Supreme Court overturned a juvenile's conviction for yelling and cursing at police officers when they had detained his sister. The court held specifically, and I quote, "Obstruction statutes may not be used to limit citizens' rights to express verbal criticism, even abusive criticism, at police officers. Free speech always trumps an officer's annoyance under the First Amendment." So how do the officers justify being able to actually arrest Mr. Freeman and other people in exactly this same situation? That's when they pull out the old pesky disorderly conduct. I have done a video previously about what I think is one of the most overbroad, worst laws out there on the criminal books related to this so-called crime of disorderly conduct. Cops use this all the time. If they don't like something about you, they turn around and claim you're being disorderly. And some of the laws that are still on the books for disorderly conduct can almost include any behavior, including how you walk down the sidewalk. Go check out that video when you have time. It's amazing because what cops are able to do to justify this. But courts in most states have started to clamp down on this by saying mere words by themselves are absolutely protected under the First Amendment. And if that behavior and activity was directed toward a police officer, cops cannot use disorderly conduct conduct statutes to arrest you. Now, in James Freeman's case, you heard this McKinney police officer saying over and over again, quote, I think he said something like, "I can take you to jail just for saying that."
Give me one last time, or I'll take you to jail for me. If I tell me to shut up right now, I can take you to jail right there for that. I'm trying to deal with him, and you come over here and tell me to shut up on my own call? Absolutely not. I can take you to jail just for that.
For saying shut up?
And of course, he was claiming that he could take Mr. Freeman to jail just because he told him to shut up. As a matter of law, that police officer was absolutely wrong on the law, even though he arrested Mr. Freeman anyway. No matter how loud, no matter how obnoxious, or no matter how offensive these police officers thought Mr. Freeman was being, what he was doing was protected speech under the First Amendment, and the officers are going to be in some pretty significant trouble as we talk a little bit more about this later. But before we move on to this next point here, let's cover what Mr. Freeman could have done here that would have justified the officer to actually arrest him for interference with public duties. You remember what I covered earlier, that generally speech alone is not enough to interfere with an officer's duties. However, if there's any type of physical behavior, physical action on Mr. Freeman's part, that could change everything. For example, if Mr. Freeman had walked up and tried to physically block an officer from being able to make her arrest or an actual detain someone, that would have been a legal reason for the officers to arrest him. Or if the officers had given him a legal command, a lawful command that he should step back or do something or make sure that it's actually lawful. It's got to be a lawful command, and he chose to ignore it, that could be a reason for him to be lawfully arrested for interference with public duties. So it is important to remember that even silently standing in a police officer's way or refusing to obey a lawful command can be used, and cops love it when people do this. They look for exactly that basis as a reason to arrest that individual for interfering. And here's one more big one. Be careful. Refusing to provide your identification after being legally and lawfully detained, many times and in most states, not most, but there's a good number of states under case law where officers can actually take that refusal to provide that identification and claim you are actually interfering with their public duties. How? Because the officer will claim their request for your ID was tied to their specific investigation. And there's a Fifth Circuit case out there that would actually potentially support that reasoning. But just saying, shut up, or leave him alone, or you're an idiot, or I don't like this or that, or just making verbal statements is not alone by itself to equal interference with public duties, disorderly conduct, or any other reason because it's protected under the First Amendment. Which now brings us to number 3. What are your chances of actually being convicted? Mr. Freeman's chances of being convicted for speech-related interference. Just for saying shut up, just for saying words, opinions that you have coming out of your mouth, what are the odds of you being convicted for that? Given the legal protections and the constitutional rights that we just discussed, the chances of being convicted for this should be 0 if everything works according to the criminal justice system. But you got to remember, you've got to have a prosecutor who understands and knows the law and is not on an agenda. And you also have to have a defense attorney who's willing to stand up and make sure and take the fight, if need be, to a jury and make sure and file all the appropriate motions to suppress and do everything they can to get this case thrown out. But as we all know, the system doesn't always work like it should. In cases like Mr. James Freeman, these charges should be dismissed or dropped as soon as they make it into the district attorney's office, ideally. But that assumes someone actually takes a look at the case, references it against the law, and dismisses the charge. Any competent defense attorney, or quite frankly, any competent prosecutor, should immediately be able to see this case, see that it's protected free speech, and the case should go away. But like I said, sometimes it requires you to take it all the way up to a jury before the prosecutor either finally gives in and dismisses the charge, or you have to show that the law is on your side. As a little bit of proof that sometimes the system doesn't work like it's supposed to, there have been many cases that have actually gone all the way up through a jury trial and people have been convicted for this sort of thing, and it took appellate courts to come back around and throw the case out later. In fact, courts have thrown out countless contempt of cop arrests on exactly this basis. One classic example was the Supreme Court case from many years ago known as Terminillo versus Chicago. In that case, the Supreme Court reiterated, like they had done previous times before, that this arrest should have never happened because provocative and maybe even aggressive, maybe offensive words are still protected under the First Amendment speech. And as a result of that, cops should restrain themselves, and there really should be a price to be paid when officers choose to ignore their training and experience and try to step over that line and act back in retribution. And what about if cops try to go that disorderly conduct charge route, and so they try to get a little crafty here and try to find another way to go after this, you remember the case I quoted you earlier, Houston versus Hill. It covered exactly this issue. In Houston versus Hill, the court was very clear that all provocative words made in protest to a police officer, directed at an officer, and only words that were not fighting words and something that would lead to specific actual violence are protected under the First Amendment, and disorderly conduct laws, no matter what state you're in, cannot be twisted and manipulated by police officers as a pretext to arrest you. So if an aggressive officer approaches you, starts treating you wrong, and maybe being abusive to you in a particular situation, and you respond back, attempting to stand up for your rights, and they quote you some generic statute claiming disorderly conduct or interfering with public duties, remember, that is a baseless, toothless claim that they have no basis to use against you, and it will be considered First Amendment protected speech. Now, you might be able to beat the charge 100%, but it doesn't mean you'll still beat the ride, because officers in this situation may still choose to punish you and act out of retribution because of the words that came out of your mouth. So now we know the chances of James Freeman being able to have his case dismissed or be acquitted in a trial are probably up there near 100%. But that brings us to the next question and our final point here, which is, what are the chances now for Mr. Freeman or anyone else who faces this situation to be able to overcome the hurdle of qualified immunity and actually bring a Section 1983 federal civil rights lawsuit against the police department and collect money damages for police mistreatment? This brings me to the way that you can bring a civil action against a government official, and specifically police officers, which is 42 U.S.C. Section 1983. A federal law. In this situation, Mr. Freeman could claim that these officers, this particular officers, violated his constitutional rights in two specific ways. Number one, he violated his rights under the Fourth Amendment. How? He actually arrested Mr. Freeman without any probable cause whatsoever. But then he violated his First Amendment rights by arresting him for protected free speech. In Mr. Freeman's scenario, the arrest certainly lacked probable cause because we now know it's not a crime to tell a cop to shut up. And it certainly looked like it was a First Amendment violation here because he was retaliating against Mr. Freeman for protected speech. That's pretty clear he should have known every bit of this when he came out of the academy. But as we know, what should be doesn't always turn out to what it is under the doctrine of qualified immunity. Qualified immunity is a legal doctrine that shields government officials from personal liability unless they violated, quote, clearly established law. Overcoming qualified immunity is a two-step process for Mr. Freeman and anyone else who wants to bring an action against the police. Number one, you must show that a constitutional right was violated by the officer's conduct. Here, this is pretty straightforward here. Arresting someone without probable cause is definitely a Fourth Amendment violation, and retaliating against them by arresting them for free speech, something they can say under the First Amendment, is definitely another violation. So prong one to overcome qualified immunity is definitely met here. Mr. Freeman's rights were absolutely violated. Which brings us to point number two. In addition to showing that a constitutional right was violated by the officer's conduct, Mr. Freeman must also show, number two, that the rights in question were, quote, clearly established at the time such that a reasonable officer would know that they were 100% violating the law. In other words, was it already clearly established under the law that you cannot arrest someone for verbally saying something that's offensive or filming them? In this case, yes, absolutely. This is not something new that just came out of thin air. This has been the law, and cops have been trained on this law for decades. Now, many officers will argue, and prosecutors will argue, that cops aren't supposed to be constitutional scholars. And maybe that's true, but any competent police officer would have been trained on this and is expected to know the basics, which is what? You can't just arrest someone because you don't like them or what they said, particularly when it's protected under the First Amendment. In fact, if I was standing there next to Mr. Freeman, arguing on his behalf in front of the court, I would point to these particular cases I'm going to give you right now as more than establishing this was established law and that this officer absolutely should reasonably have known it. Number one, Houston versus Hill. If you remember, we covered this was a case that clearly established that verbally opposing police is protected. In fact, the court in that case said that speech alone is not interference with public duties. Furthermore, that brings me to Freeman versus Gore. In that case, the court was crystal clear that shouting at officers is protected speech under Texas's obstruction law. And in Turner versus Driver, the Fifth Circuit made it crystal clear that you have a First Amendment right to film the police in public. In fact, the court said that if recording an officer in public is protected, then speaking words is also protected under the First Amendment. Given this body of case law, any reasonable police officer would know arresting someone for just what they said or filming them, they are on the wrong side of the Constitution, and that qualified immunity is now shaky for them. They may be held civilly liable. So where does that bring us for Mr. James Freeman? Well, number one, we established both prongs were met. Why? Because number one, his rights were violated. And number two, those rights were clearly established at the time of the incident. As a result, Mr. Freeman has a very strong claim that these officers are not entitled to qualified immunity in a federal civil rights lawsuit. You say, well, Jeff, what does all that mean? Well, in practical terms, that means Mr. Freeman or anyone else finding themselves in this situation can now bring a civil rights lawsuit in federal court, a Section 1983 claim against these police officers. And even if they have to take it all the way to the trial, they will have a legal cause of action that will allow them to have their day in court and potentially be able to actually recover in civil damages. You say, well, Jeff, what's the actual possibility that this case could turn out favorably from a money judgment position here? Well, if you go and you look and you find cases where cops acted like bullies and they decided to arrest people for things that constitutionally were protected, you'll find that many of those settlements can reach easily well into the seven figures. And you'll also find out that sometimes juries punish those officers, take that taxpayer money, and actually hand it over to people whose rights were violated to send a message to police that they cannot violate people's rights. For example, in the Duren case I mentioned earlier, those officers lost their qualified immunity on appeal. That opened the door for Duren to win a significant monetary damage award for the actions of the police in his case. Similarly, if Mr. Freeman chooses to go that route, he stands a great chance here of being able to recover a judgment because the officers took it too far. And you don't want to forget, when this happens with police departments, it's also possible Mr. Freeman could bring in what we call municipal liability for an even greater damage return. What is municipal liability? Well, and this can be a little bit harder to prove, but if you were to find that there's a pattern or practice of that local municipality, that police department, of arresting people for exactly this sort of behavior, and it's happened over and over again, that could show a pattern and practice of a municipality violating constitutional rights, and that can result in an even greater judgment. But, and the final thing I'm going to say about this, watch out for cops looking for other little sketchy, shady reasons as the reason they claim to arrest you, when in reality they were retaliating. This is one of the areas I see qualified immunity, where they're able to still receive the qualified immunity and come up with some other legal reason for the arrest. For example, this officer in this case might try to claim he wasn't trying to actually arrest James Freeman because he said shut up, but he was going to arrest him because he thought he stepped out over onto the roadway, or he did something in such a way that was a separate, even a small traffic related offense, or a jaywalking or impeding someone else, or in some threatening manner. He literally could scour the traffic code and or the penal code to look for any other small violation to come up with that as the other offense. But the bottom line is the same. An arrest without probable cause is absolutely unconstitutional, and to do so by retaliating because you are exercising your First Amendment rights to free speech can be a means by which for police officers to be held liable, and they would lose their qualified immunity. Speaking of police officers making up reasons to arrest you, did you know that officers can lie to you? And sometimes they'll ask you dumb questions to bait you into saying something they can now arrest you for, just like James Freeman. Check out this next video where I break down police lies and dumb questions and the top responses and answers you can use to stop them in their tracks. See you over there.